Welcome back. We will now begin session 3, Advancing and Sharing Scientific and Legal Technological Innovation to Grow Economies. We have Mr. Amirali NASIR, Vice President of the Law Society of Hong Kong, as the moderator. Speakers of this session are Mr. Syed Musheer AHMED, Founder and Managing Director of FinStep Asia. Professor Chao, Dean of Faculty of Law of the Chinese University of Hong Kong. And Mr. Jianwei, Vice President of All China Lawyers Association. Our moderator and speakers, the floor is yours.
Thank you very much. So I'd like to start off by asking you to think about I spoke about this to the table at the back. Think of a mammal which is gray in color, has a horn or two. It's big, scary, and dangerous, right? Anyone think about it? No? It's actually a friend, a living thing that is entitled to inhabit this precious earth with us all, like all inhabitants of the BRI countries. It's scary only to those who do not know how to approach it with respect, right? It's, of course, a gray rhino, and actually it's a metaphor for a highly likely ignored threat. Of course, it's not a threat. It's coined by Michelle Wucker in her book, The Gray Rhino, How to Recognize and Act on Obvious Dangers We Ignore. Our title is Advancing and Sharing Scientific and Legal Technological Innovation to Grow Economies. I'm going to have 3 eminent speakers who will talk about various aspects of this. Mr. Jianwei is going to, Vice President, All China Lawyers Association. He'll be looking at the global view of regulation, data aspects in mainland, which is very important. And then we'll have Professor Chao, who will talk about matrices, regulatory issues, which is a bit more specific. And of course, we'll end with Musheer, who will talk about specific technologies that can be used in the legal industry and things like blockchain and how they could be used as well. Of course, bear in mind what Mr. Yang has to say about the regulatory issues and data privacy as well. So with that, I'd like to invite Mr. Yang, please. You want to go to there, or do you want to say, yeah? Okay.
各位嘉宾、女士们、先生们，大家下午好。非常感谢香港律师会在今天的论坛的第3个环节，就是以推动和共享科技与法律的创新技术促进经济发展这个第3个环节让我来跟大家进行分享。我想在这个环节跟大家交流的内容是以高水平的法律服务，富含数据产业的发展。习近平主席指出，推动实施国家大数据战略，加快建设数字中国。数字中国建设是在数字时代推进中国式现代化的重要的引进。从2016年以来，我国陆续的颁布了一系列的法律规章，特别是在2001年开始，我们颁布了网络的安全法、数据的安全法、个人信息的保护法。在前年的12月，中共中央、国务院又印发了关于构建数据基础制度更好发挥要素作用的意见。这个意见，它对这个我们国家的数据产业的发展具有非常重要的意义。它有3个方面的主要的内容。那么第一个方面呢，就提出了 要建立数据资源的持有权、数据加工的使用权、数据产品的经营权。我们这个做律师的都知道，我们经常接受的是所有权，所有权的4大权能，这个占有、使用、收益、处分。但是我们这个制度在数据产业的这方面的产权制度，这个构建了3项重要的权利，就是这个数据资源的持有权、数据加工的使用权、数据产品的经营权。同时，这个意见还提出了要培育数据要素流通和交易的服务的生态，同时要求构建数据安全合规、有序、跨境流动的机制，为加快数据的要素的价值的提升、培育、发展数据要素市场指明了方向。数据要素是赋能行业数字化转型和智能化升级的重要的支撑，但在数据要素的市场化改革的进程中，目前仍有不少的问题，需要我们去探索相应的解决的方案。我们律师行业要顺应数据产业发展的方向和趋势，我们要充分运用好我们的专业的优势和实践的优势，为我们相关的组织机构提供合规服务，为行业规则的制定、为制度体系的建设、为国际合作与交流等等来提供我们的智库方面的支撑。下面我就从3个方面同大家分享一些体会。第一个方面是要为数据要素市场配置化改革贡献律师的力量。数据是新型的生产要素，我们过去提的生产要素包括土地、劳动力、资本，而数据是一项比较重要的新兴的生产要素，它是数字化、网络化、智能化的基础，目前已经快速地融入到了生产、分配、流通、消费等等各个环节。那么，数据要素市场化配置改革，它是释放数据的价值、促进经济增长的重要的途径。那么，怎样的进行数据要素的市场化配置改革呢？那么，我们重要的是要聚焦数据要供得出，要流得动，要用得好，要保安全。同时我们要通过完善数据基础的制度体系，要促进数据的开放共享，要推动数字基础设施建设，要培育数据的产业生态等等的举措。那么，我们最终的目的是什么呢？要使我们海量的这个数据的优势转化为国家的竞争新优势。那么，我们回到我们律师行业，我们律师行业在服务数据要素市场化配置改革时，我们常常会面临一个非常重要的问题。那么是什么问题呢？就是这个数据的确权难就是确立这个权利不是很容易的一件事。同时数据的安全与隐私的保护也是我们现在面临的一些难题。那么上述我讲的这个意见，它就创设了数据三权分置基本的权利的体系。它鼓励多种数据通过授权运营的方式来进行发展。但是，对于数据的持有主体而言， 因为数据它存在无形性和可复制性，因此数据资源的刚才说的商权、持有权、使用权、经营权，在实践中往往遇到这个权利较难确定、较难界定。那么，我们律师行业它的主要的职责就是要运用好我们的专业的能力，来帮助数据的持有的主体进行专业的分析和判断。它要解决3个问题：一是要解决这个数据资源、资产、权所关系模糊不清的问题；二是要明确数据资源可开发、可利用、可交易的边界，我们要把这个边界要把它找出来；三是要保护好用户的隐私。我国有巨大的数据资源存量和海量的数据的应用的场景，但是数据交易的活跃的程度和数据资源的禀赋优势，还需要进一步的激活与释放。作为律师，应当参与数据交易流程的各个核心的环节，帮助企业系统的梳理并确定其数据资产的价值，协助企业进行数据交易的磋商。这是第一个方面。那么第二个方面，我们律师要干什么呢？就是要深度地参与新兴领域市场规则的制定，保护好数据的创造者和经营者的合法的权益。第三个方面，我们律师要帮助各方的主体探索公共数据、企业数据、个人数据。我们这个数据持有的主体核心就是公共数据，企业的数据和个人的数据。这3个不同的数据的类型，它的价值释放的合规的途径，促进数据资源共享和数据运营机制的不断的完善。这是我想跟大家交流分享的第一个方面的认识和体会。第二个方面，我们律师行业要为企业数据资源合规管理提供精准的服务。数据资源入表是数据资产纳入企业财务报表的一项重要的举措，在2002年、2003年以后一直在探索。在去年，我国财政部对外发布了企业数据资源相关会计处理的暂行的规定。那么这个规定呢，它的核心内容是2个方面，那就是对于这个数据的资源怎么样的进入我们的财务的报表，就是我们经常所说的资产负债表，提供了相关的途径。那么有一部分的数据资源可以作为无形资产，有一部分的数据资源可以作为存货。那么能够入表，它有什么好处呢？它提升了这个企业资产的价值。我们知道，我们律师行业经常服务于这个并购、股权的转让。如果我们的数据资源能够入表，进入资产负债表，那么它就体现在了那个所有的权益净资产里面，对于这个转让者的这个他所持有的股权的价值就有显著的提升。同时，这项制度非常重要，它也规定了，如果按照相关的财务会计的一些制度，不能入表，但是它可以通过销售产生收入，一样的转化为另外一个形态，就是我们的资产负债表里面的这个收入的这一部分，资产这一部分，只是换了一个形式。这个暂行规定的出台， 在数据资源核算的实践中，它具有里程碑的意义。数据资产入表必将促进数据资产价值的提升，必将进一步推动企业数据资源合规管理机制的健全完善。那么，我们律师行业在这个数据的资源变成我们财务报表中的无形资产和这个现货的时候，我们能做什么？我们要服务什么？我们的服务分为5个方面。第一个方面就是要帮助企业审查数据来源、收集方式及使用的合法性，我们要解决合法的问题。二是我们要负责起草好、修改好数据资产交易、使用许可等等法律的文件，就是我们经常干的这个起草、修改、完善法律文本的工作。三是我们要出具相关的法律意见，这个意见的内容是什么？就是涉及到数据的合规、数据的保护、隐私的保护、网络的安全等等方面，我们要出具相关的法律意见。四是呢，我们要帮助企业识别和评估企业在数据处理的活动中的法律的风险，就是有什么样的法律风险。五是我们要协助企业解决好因数据资产权属引发的争议等等。总之我们律师行业在数据资源入表的过程中，不仅可以帮助企业处理好相关的法律问题，还能通过提供专业的服务，帮助企业防范风险，加强企业数据资产的合法性、合规性和有效性。第三个要分享的是，我们律师行业要为促进和规范数据跨境流通展现我们的专业的能力。近年来，伴随着数字经济的快速发展，跨境数据合规和治理的这个重要性日渐凸显。它不仅关系到国家的安全、企业的发展，更是国家和地区之间开展合作的基础与前提。因此建立高效、便利、安全的数据跨境流动的机制，在保证数据安全的前提下，规范数据的跨境的流通，已成为数字经济和数字贸易发展的关键，并且对促进数字的产业化和产业的数字化具有重要的意义。那么，我们律师行业在促进和规范数据的跨境流动中，它必将扮演着重要的角色。律师将通过法律审查、法律咨询，首先我们要帮助企业合规地开展数据的跨境的流动的业务，确保企业在跨境的数据的传输中遵守相关法律法规，有效地防范法律风险。那么其次律师要基于对数据跨境相关政策的精准的理解及把控，要为相关的组织机构提供定制化的专项的服务，比方说为企业精心构建并优化跨境数据流通的合规的架构。我们要引导企业进行数据出境的自我评估，助力企业在数据出境方面顺利地通过安全的评估，为企业数据跨境的运营与管理奠定坚实的合规的基础。那么最后呢，我想说明一点，数据跨境的流动的法律服务专业性特别强，涉及面特别广，所以我们律师行业要不断地更新自身的知识的结构，不断提升我们行业的服务的能力，为护航数据跨境安全有序的流动做出我们行业的 更大的新的贡献。谢谢大家。
Well, that was an excellent presentation, Mr. Yang. We've talked about data being the new gold, data value, data markets, digitization, digital trade, digitization of industries, and looking at all the other risks, what lawyers have to do, valuations and shares. There's a lot to do as far as we are dealing with clients, and data is on the accounts and how we should deal in accounting standards with that data when we're acting on behalf of our clients. Mr. Yang has already identified the cross-border issues, legal issues that need to be covered. We, of course, in the Law Society, as solicitors are concerned, we have Principle 1.07 that talks about the professional conduct standards that apply to you when you're dealing with technology. And of course, we have Principle 1.08, which talks about your obligations at a professional conduct issue when you're dealing as a lawyer in a different jurisdiction. And those are common features as far as we as lawyers are concerned. But what Mr. Yang has identified is crucial issues about data when we're acting for clients who have data as an asset or an inventory on the records. And that's very interesting. Perhaps we can talk about that a bit more. So let's hear from Professor Chao, who will talk about investment on an index-based assessment of the legal and regulatory risks in the selected Belt and Road economies. Professor Chao.
Thank you, Mayor. Thank you, Chair. It's a great pleasure to be invited to take part in this wonderful conference. Big thanks go to the Law Society for the invitation, and huge congratulations to the organizers for having put together such a wonderful event at such a splendid venue. My presentation, I believe it's now up, is based on a research project of mine conducted at the Chinese University of Hong Kong, resulting in the publication of one of the first English language research books on the legal aspects of the Belt and Road Initiative. The project derives from a couple of very generic questions which pretty much arose from our intellectual curiosity. Now, these questions are, is the rule of law particularly weak in countries of the Belt and Road Initiatives? Are legal and regulatory rules particularly unfriendly to businesses in the Belt and Road countries? So these are the questions that concern academics, policymakers, investors, and the like. Yet there's no easy way to answer these questions. Part of it is because the Belt and Road countries are highly diverse in their national conditions, ranging from Russia to Maldives, from Singapore to Afghanistan, and from Iran to Israel. Therefore, the Belt and Road countries could hardly be treated as a homogeneous group. Perhaps the opposite is true. Now, from the investor's point of view, the Belt and Road countries, they represent significantly varying patterns of risk and benefits. Now, take the World Bank's Doing Business project, which had been discontinued recently. As an example, that project presents a rather telling picture. The DB index, the Doing Business Index, measures the rank extent to which a country's regulatory environment is conducive to the starting and operation of a local firm. So the idea is that the higher the ranking, the easier it is for a local firm to form and to operate, and vice versa. Amongst the Belt and Road countries are some of the highest ranking countries. For example, Singapore, it ranks at the very top, as well as some of the lowest ranking economies. Now, for example, Yemen, Syria, and Afghanistan, they cluster at the very bottom of that doing business rankings. Now, having said this, an overall assessment of the Belt and Road countries as a whole with regard to their legal and regulatory risks serves a very important purpose. Now, despite their profound economic, political, social, and cultural diversities, the Belt and Road countries have been treated as a collective conception in the current academic and the policy discourses. Thus, a broad brush measure of the Belt and Road countries' legal and regulatory risks provides a rather useful reference point for discussions on the legal aspects on the Belt and Road. There are different ways of assessing the quality of laws and regulations in the Belt and Road countries. One way is to simply carry a detailed country-level analysis of each individual Belt and Road countries using a conceptually coherent and methodologically robust analytical framework. While this approach is powerful, it requires accurate and reliable information, which is not necessarily forthcoming in every Belt and Road countries, and the scale and scope was well beyond the reach of my research. An alternative approach is to base our measurement on existing indexes and rankings, in particular those that are established, reputable, and respectable. This index-based approach is admittedly not without methodological challenges. Yet it helps yield findings that inform the central inquiry of my research, which is to measure the quality of legal and regulatory environment in the Belt and Road countries on a global scale. So my research identifies 4 important and influential indexes that quantitatively measure the rule of law and the quality of the regulation around the globe. Now, these 4 indexes include the World Bank Doing Business Index, the World Justice Programme's Rule of Law Index, and the Worldwide Governance Indicators, Regulatory Quality Index, and the Rule of Law Index. So my research then develops what I call a Belt and Road Index on the basis of these 4 identified indexes in order to measure the relative strengths of the Belt and Road countries' legal and regulatory environments on a global scale. The first index covered in my research is the World Bank Doing Business Index. Since its inception in 2002, the World Bank DB project and its annual reports had become one of the world's most influential resources for quantitative measurement of business regulation around the globe. The project measures business regulations and their enforcement in close to 200 countries. And each of these economies is ranked on its relative ease of doing businesses. To be more specific, the DB project looks into 10 areas of business regulations, as shown on the slide, in order to develop an overall ease of doing business in ranking. The higher an economy ranks, the more conducive the regulatory environment is that economy to the starting and operation of domestic small and medium-sized enterprises. The DB project has been an influential source for academics, policymakers, and the like to undertake cross-country comparison of business regulations. Despite the DB's significance and the popularity, it is not without criticism. The DB has been criticized for having taken our approach to regulation that is, quote-unquote, deeply misguided. The DB has also been accused of being biased against continental European legal traditions, in particular the French legal tradition, in favor of common law. As many of you would know, the DB project has been discontinued since 2021. Now, having said all this, the DB offers a rather useful tool for the purpose of my research to understand the relative strengths of the regulatory efficiency in the Belt and Road countries on a global scale. This slide visualizes the DB scores of the 65 selected Belt and Road countries using the DB database back in 2016, the year in which no controversies were immediately discernible. It demonstrates that the Belt and Road countries spread widely in a DB spectrum and indeed appears at both ends of the spectrum. Now, take Singapore, for example. it ranks at the very top of the DB rankings, whereas Afghanistan occupies a place at the time number 177 globally, close to the very bottom of those rankings. Now, as shown in the table at the very bottom of the slide, the mean value of the Belt and Road countries' DB scores was 65.21, and this was comparable to the mean value of all countries that was 65.47 at the time. The median Belt and Road countries' DB scores at the time was 65.31, and it was considerably higher than that of all countries measured by the DB project, which was 61.05. Now, this actually suggests a very interesting, if not counterintuitive, finding that the Belt and Road countries tend to concentrate closer to the top rather than to the bottom of the DB rankings. The second index adopted by my research was the World Justice Programme's Rule of Law Index. The WJP and its annual publications on the Rule of Law Index has a very important source of quantitative measurement of a nation's adherence to the rule of law. In scoring and ranking the rule of law in the country, the WJP's Rule of Law Index, it takes into account 8 factors as shown on the slide. Its approach to measuring the rule of law is rather unique. WJP's Rule of Law Index is based upon experiences and the perceptions of the general public and in-country experts. So this ranking emphasizes on how people experience the rule of law in their day-to-day lives. While it is methodologically robust, the Rule of Law Index faces a quote-unquote notoriously difficult challenge of defining the very concept of the rule of law in the first place. The notion of rule of law is known for its conceptual complexities and multiplicity. The WJP's rule of law approaches the definition issue by focusing on, quote-unquote, the outcomes that the rule of law brings to the societies. It claims that its index is, quote-unquote, based upon 4 universal principles deriving from internationally accepted standards. The distribution of the ranked Belt and Road countries is visualized on this slide. It demonstrates a pattern that differs from the pattern of the Belt and Road countries in the DB project. They tend to cluster in the middle of the global rankings. The third and the fourth indexes relied upon in my research are 2 of the world governance indicators. These are the Regulatory Quality Index and the Rule of Law Index. The worldwide governance indicators have been an impactful resource that informs academics, policymakers, donor countries, and institutions, and the like on the quality of country-level governance around the globe. It quantitatively evaluates the quality of governance of as many as close to 200 countries, making it truly global in coverage. In the interest of time, I will not delve into the methodological considerations used by using these 2 indexes. Now, the scores of the Belt and Road countries in respect of the rule of law quality, the regulatory quality and the rule of law are shown on these 2 slides. Now, the 4 indexes discussed above are all important and influential resources for assessing the legal and the regulatory risks in the Belt and Road countries. While these indexes arrive at broadly consistent conclusions, there are instances of variations. Now, take Turkey, for example. When it comes to rule of law, the WJP ranking and WGI, they vary greatly in assessment of Turkey. The WJP's Rule of Law Index puts Turkey in the bottom 25 percentile, whereas the WGI Rule of Law Index ranks Turkey in the 50 to 75 percentile. Belarus is another notable example. Its ranking the DB falls into the top 25 percentile, whereas in the WGI's regulatory quality ranking, it was actually in the bottom 25 percentile. Now, these variations, they do not come as a surprise. The 4 indexes base assessments on varying conceptual constructs, methodology approaches, and sources of data. Therefore, their conclusions can and sometimes do differ from one another. It is very important, however, to have these differences reconciled in order for them to be collectively form the basis of assessment of legal and regulatory risks in the Belt and Road countries. So my research, in order to achieve that, my research processed a somewhat a new index, which was called an OBO index. This index draws upon the 4 indexes to be more specific to the extent they are available. A given Belt and Road country, countries ranking each of the 4 indexes is assigned a value ranging from 4 to 1, depending on the percentile in which that ranking falls. When the ranking is in the top 25 percentile, a value of 4 is given. A ranking of the 50 to 75 percentile is assigned a value of 3. And 1 in the 25 to 75 percentile to 50 percentile, a value of 2. A value of 1 is then assigned to a ranking in the very bottom 25 percentile. This index, the OBO index, is the mean of these 4 values. To use Turkey again as an example to demonstrate this approach. Expressed in percentile terms, its ranking the 4 indexes are, respectively, the DB, 68.8 percentile, WJP Rule of Law Index, 21.6 percentile, WGI Regulatory Quality, 60.35 percentile, and the WGI's Rule of Law Index, 59.62 percentile. These rankings were then translated and assigned the values of DB3, WJP Rule of Law Index 1, WGI Regulatory Quality 3, and the WGI's Rule of Law Index 3, respectively. Thus, the OBO index for Turkey is 2.5, being the mean of Turkey's values in these 4 indexes. Using this method, this slide visualizes the OBO index of the surveyed these are surveyed Belt and Road countries. So obviously there are 2 limitations of this very exercise of OBO index. Number 1, and the most notable limitation is methodologically it is a mathematical mean of the 4 indexes that are otherwise not necessarily coherent given their varied conceptual bases, methodological methods, and the source of data. The OBO index is crude and primitive and can only be indicative only. It does not intend and cannot substitute for methodologically more sophisticated and nuanced indexing exercise. Now, secondly, and apparently, the OBO index measures the legal and regulatory risks from the point of view of the rule of law and the quality of regulations as defined in those 4 indexes. Having said that, the OBO index does offer certain advantages. It serves as a convenient reference point. It indicates the relative strengths or weaknesses of a Belt and Road country's legal and regulatory systems as measured on the global scale. An OBO index of a score of 2 is a cutoff point, and a country of a score of 2 is perceived by the 4 more major indexes as weaker than the global average in the rule of law and the quality of regulation. Now, applying this benchmark, 43 out of 64 surveyed Belt and Road countries are above the 2 score of 2. In other words, slightly more than 2/3 of the Belt and Road countries are actually better than the global average in their legal and regulatory environments. This result is broadly congruent with the 4 indexes in which the OBO index has been constructed. Now, to conclude, a myth about the Belt and Road countries is that they are filled with legal and regulatory minefields, and that weak legal and regulatory systems make it riskier for investors to invest and do business. This research sheds some light on the myth. It identifies 4 major indexes that have been widely used by academics, policymakers, and donor institutions around the globe. It shows that as measured by these indexes, the Belt and Road countries are as a whole not riskier than the global average. Indeed, by some measures, for example, measured by the DB project, the Belt and Road countries are actually more likely to be found in the percentiles closer to the top of rankings rather than to the bottom. Another key contribution of this research is its development of our overall index. It shows that more than 2/3 of the Belt and Road countries are above the global average, as defined by the index exercise, a finding that is actually broadly in line with the 4 indexes on which the index is based. That concludes my presentation. Thank you for your time. Thank you.
I think you will agree that you've never heard such a presentation before, because Nick, you will agree, right? What Professor Chao has just done is, when we deal with law, we always look at qualitatively how good it is to know. But Professor Chao has just proved that you can quantitatively at least analyze the rule of law index, which is fantastic. I mean, it's out of the box thinking, to be able to present something which gives you a pictorial image of the rule of law. It's fantastic. It indicates the indices that have been used. It shows what Ms. Yang said is data is gold. And what Professor Zhao shows is that the rule of law is gold, right? And it is, in fact, if you don't have the rule of law, then you have the gray rhino, which is highly likely yet great ignored threat to business world if we don't have a rule of law and technology, if we don't have proper administration and dealing with data, both as an asset or in our profession. So it's an excellent presentations, Professor. I love listening to all your presentations, not just this. I'm not just being favorite, but actually I should go back to university with some of your classes. So now, let's focus more on the application of technology in the legal industry, possible applications. And Musheer has spoken for the Law Society and the Islamic Finance Committee. He's an excellent speaker. He will present you with the wonderful ideas, out-of-the-box thinking on how technology can be used. So Musheer, go ahead, please. Thank you.
Thank you. Honorable members of the government, distinguished guests, and my fellow panelists, and everyone present here, it's an honor to be speaking and talking about 2 very interesting innovations and technologies that some of which are very familiar to you and some which are newer to broader legal profession as well as the enterprises globally, right? So the aim of my presentation today is to kind of shed light on the evolution of artificial intelligence on one hand and blockchain on the other. There is a third piece that probably I can come in next year to talk about, which will be the amalgamation of both artificial intelligence and blockchain, which we are starting to see. However, the aim here is, one, let's talk about how artificial intelligence has evolved and how the legal profession is both dealing with utilizing artificial intelligence for your day-to-day work, while on the other hand, dealing with law and regulatory elements of artificial intelligence, and similarly for blockchain. Before I kick into the presentation in earnest, how many of you here have used some shape or form of artificial intelligence in your work over the last 5 years? Show of hands, those who have, right? Okay, a decent number of you. Some of you may already be using ChatGPT and not realizing, but one of the oldest artificial intelligence tools that I'm sure everybody's used is a simple tool where you are checking your spelling, right? So spell check is nothing but an algorithm which is detecting whether the spelling that you have based on the database, just reviewing and saying, you made an error and these are the suggestions for your possible spelling, right? So now you may not think of it as artificial intelligence, in very much so as how we would not think of calculators as being computers, right? But they are probably the first form of evolution of the computers would be calculators. In a similar way, artificial intelligence has been around as a concept and been deployed across for over 60 to 70 years, but the key changes have probably taken place because of data and the availability plus the ability to structure data and being able to process that. Mr. Yang mentioned about how big data can be very useful for a variety of different elements of regulations as well as enterprise. In a similar way, we now have the ability to use data in a variety of ways, which then allows algorithms to build on top and utilize to develop artificial intelligence, as is the case in today's world. The next slide is a survey that was done, a survey that was done with regards to how AI in legal profession is seen by those in the legal profession. This is a Thomson Reuters report a few months back. And you can see 6 out of 10 people in the legal profession are optimist, 4 out of 10 are pessimist, right? Now, that may be because some of them are scared, some of the people are worried about the impact on jobs going away, right? Now, my question would be, a lot of us here maybe were there at a transition of the internet, right? So pre-internet, yes, you had computers, but the way people reacted to the internet was that many jobs will be lost. Then came the mobile revolution, where again there was expectations that many jobs would be lost. My view on artificial intelligence impact is that it's not jobs that will be lost, it will be roles that will be lost, right? Certain particular roles which are applicable in terms of, in particular, data handling, data management, right, simple analysis, etc., will go away, and there'll be more time for higher qualitative work that can be done. So it's more roles will transition. Technology, in fact, has created millions of jobs, if not hundreds of millions of jobs globally in countries in Asia, as well as in the Belt and the Road, which have been big enablers and drivers of the economy, right? So prior to IT, as it were, when you look at India, you look at made in China, you look at many other countries, those are engines, a big engine for the economy, right? And driving employment at scale. So jobs don't go, it's roles that go and they'll transition, right? And in a similar way, when we move to looking at applications of AI in legal profession, they could be applied across a variety of different elements, ranging from contract management, right? Simple contract management. A lot of contracts are already templated, right? There's a small change, maybe 5 to 10% that's tailored in a broader percentage if you talk about the number of contracts. So you can have contract management. You can look at document drafting and negotiations, right? Similar element. You have a bunch of startups already. This is just a snapshot of some of these startups who are using, providing AI-related services for the legal profession. You have IP management. I think that's going to be a major piece of element that AI can help. Now, with the data and availability of cross-border data or global data, as it were, you can avail more information at a faster speed in today's world, right? Irrespective of where the data is based. Now, legal research. Earlier, you would use, as I mentioned, you'd use a simple algorithm to check the correctness of the work. Now you will use humans to check the correctness of artificial intelligence. And I'll touch upon Gen AI as generative AI next up, but broadly speaking, you will have a lot of individuals whose specific role will start becoming to check the output that an artificial intelligence agent produces. As an example, one of the most highly paid jobs that came up over the last 3 years is a role known as prompt engineer, right? So what is a prompt engineer? It's an engineer that can create the right prompts for generating output from artificial intelligence agents, right? This wasn't really in existence previously, but is among the highest paid jobs because people need experts who can cater to it. In a similar way to what we see in terms of online content management, KOL, etc., this is another thing that you see from where technology has supported elements of growth. So again, some of the different, sorry, one second. When we look at different use cases, as I said, you can be best case law identification, especially in countries which probably use common law and have a broader depth of cases that they can rely on. You could have that. You can have briefs that can be, there can be composition of briefs. You can have predictive analysis for case outcomes. In a lot of ways, when you're looking at legal decisions, there is a human element to it, which is based on clear laws that have been laid out. There's also an opinion-based, right? But you could, in a similar way, you may say the medical profession is also, there are rules and there's science behind it, but there's a lot of opinion of what a certain cardiologist or a cancer expert or a surgeon thinks about when going in for treatment, right? And that's why a lot of people take a second opinion, a third opinion. In a similar way, you've had AI like IBM Watson and others, including in mainland China, we've seen examples where AI is able to detect and predict different kinds of diseases, as well as the best way for treating these diseases. In a similar way, you can have artificial intelligence for legal use cases that can also be applied. So, here we go. Now, one of the major reasons there's a lot of noise, you can call it that, around artificial intelligence over the last few years, in particular the last 2 to 3 years, is been around the concept of Gen AI, right, or generative AI, where you have large language models, which means they're using a huge amount of data and are learning, self-learning, and are able to respond almost like humans, not necessarily fully like humans, but almost like humans. And now, that has been supported because of the growth in chips and as well as the ability to process this data at speed with proper technology. You've had very fast development. OpenAI was one of the first ones, but the progress over the last 1 year in terms of large language models, both in the US, but also in mainland China, has been quite staggering. And you now have agents that can do everything for you, almost, right? So we, as FinStep Asia, we have a regular fortnightly newsletter, which is just headlines of different important events that took place or news that took place in Web3, blockchain, and fintech. We fed that into Google's Notebook LM AI agent, and that generated a podcast of 2 AI agents discussing the news as any humans would, right? And giving their opinion on those news. There was about 30 minutes of data that was produced, and it was fairly good, in my opinion, right? And you're seeing that happen more and more, where you can have artificial intelligence agents supporting your work. Now, what this brings into picture is regulatory policy and compliance issues, right? On one hand, Gen AI can be very effective as an assistant, as I've already mentioned, on a variety of different legal elements, but it also brings in challenges in terms of how are you going to regulate anything that to do with AI. You have policies. Both mainland China has had AI policy about 5 to 6 years ago, if I stand corrected, on the date that it was issued. Hong Kong has also recently issued its own AI policy. So we are looking at policy that's coming out, but regulations globally have lagged behind. EU has come out with an AI Act, but in financial services, we're still lagging behind in terms of being able to articulate effective regulations that can stay in line with the technology. The biggest challenge is that technology is evolving so fast that prescriptive regulations and laws no longer work because they are very rule-based, right? Whereas principle-based regulations and laws is probably the way forward. This is something we've seen happen in financial services and fintech in particular, where technology started reshaping how financial services delivered. So you've seen that changes take place. Copyright is another issue that we're seeing take place. A lot of the generative AI programs or models are taking data from everywhere. As an example, OpenAI and others could take in a lot of videos from YouTube, right? And when somebody wants a video to be generated, they could be using elements from a variety of videos, and there's no copyright there. So that becomes problematic because copyrighted material and IP is being used. So how do you distinguish and how do you find it out? That is a big challenge that exists, and that's where laws would be required, and lawyers, of course. There is the element of deepfakes. This is going to become more and more challenging. Deepfakes, for those who don't know, are essentially both video as well as audio models or outputs, as it were, where the artificial intelligence is mimicking a person. It's very person-like, looks like the same person. It could be similar to, say, Barack Obama or Michael Jordan or whoever, and he's saying certain things, or Donald Trump in the recent election, you saw that happening with him, where words are being attributed. It seems like he is the person speaking or she is the person speaking, but it's not them, right? They have used a sample of the voice and used a video of the person to generate a video that looks exactly like the person, sounds exactly the person, but is not the same person. So being able to do the forensics on that becomes very important, but it can also cause a lot of damage before you discover that it was fake, right? So that's going to be very important in terms of how deepfakes can be handled and what will be the liabilities that are associated with the AI. That is going to be a big problem with Gen AI is who takes the liability. When you as a law firm may deploy a Gen AI agent, say from Office, so Microsoft Office, and you use Copilot, and that makes an error, who is liable? Is Microsoft Copilot responsible, or is the law firm responsible, right? Questions like these will also come for financial institutions when they deploy AI in the markets, and if there's a bad trade that is triggered by an AI and causes market harm, who is liable? At this stage, the liability is lying largely with the company or organization using it, but is it fair is a question that comes in, and there may be conversations around joint liability that come up, right? And of course, we have the issue of looking at jurisdictional challenges. Cross-border, if say the AI has been created in country X and is being deployed in country Y, and it goes rogue in country Y, how are you able to apply the law on that company in another country, given this was triggered, or if AI was used wrongly in a third country? So cross-border and jurisdictional challenges will kick in with Gen AI as well. So this is just a very quick look at the amount of generative AI that is expected to be used in legal services in the United States. The expectations is that there'll be a 15x increase from $50 billion spent right now to over $700 million in 10 years' time. So you can see there's a lot of money that's going to be spent in using Gen AI. Coming to blockchain, I'm conscious of time, so I will take you through quickly, but blockchain essentially is a database that is connected to all the users of that database in real time with a process and a chain that assimilates the data over time and can always be verified by anyone who has access to that database. Like, to be very, I'm being very simplifying blockchain. However, you can also see in certain surveys that were recently conducted by the business research company, 41% of law firms will be looking to use blockchain for transactional legal services, while up to 21% will use for business assistance, right? Now, all of this, as you can see, the data is a very common theme among all of our conversations, but data is at the crux of it because you have much better data, but it's about sharing of data and how you could use blockchain in that. So what we have seen is initially blockchains came out as distributed ledger technologies, where if, for those of you who are not familiar with blockchain, and those who are familiar, please have a little patience in me explaining blockchain to others. Blockchain or DLTs can be, in a very simple way, explained to be similar to Google Sheets, right? So those of you who use Google Docs or Google Sheets or Microsoft Online or Office Online, what happens in a Google Sheet is you are able to share an information on that sheet with multiple parties at the same time who can contribute to the data. And as the Excel sheet is updated by one person, it gets updated at real time for everybody else who has access to that sheet, right? Blockchains are very similar in that sense. You can set permissions on who can see the data, who can edit the data. But more importantly, once data has been input, that data cannot be reversed. In a Google Sheet, you can reverse the data. So if row number 20 is updated, row number 40 gets impacted because of the update on row number 20. In a blockchain, you cannot, so it is what's known as immutable. So that is a big advantage of a blockchain, where you can have distributed data, but it has immutability, which allows for, sorry, let me come back to this, which allows for transparency and trust. And because you can share this seamlessly across multiple entities and jurisdictions, it can be of very big use, even in law firms as well. In financial regulations, you can now have transactional data being shared across multiple counterparties or parties, including the regulators, the counterparties of the transaction, the investors, the companies, everybody involved can see the data simultaneously and have a copy with them, which helps in speeding up processes as well as in settlements. One of the other things to talk about is around smart contracts. Now, smart contracts are a simplified way of it is an automated technological decision-making element where, for example, when you have an auto debit in your bank, you've essentially given an instruction to the bank that when a call comes from a credit card, you will pay on whatever 5th of the month. Whenever that request comes in, the payment is made based on the amount left in your bank, right? That's an algorithm that works. Smart contracts in a similar way are on the blockchain. When a transaction takes place, it could be, for example, a monthly transaction where you are paying mortgage. The smart contract will trigger the next stage of the operation automatically when the certain conditions for the smart contract have been met. Now, these can also be used in a variety of legal use cases, and we are seeing a lot more elements of that. However, we have to also be mindful that enforceability of smart contracts is a challenge if there is no legal framework in the jurisdiction and recognition thereof, right? This also comes down to the recognition of assets, as it were, when we spoke about data as an asset, right, and the recognition in mainland about data as an asset, that makes a difference in accounting. But in a similar way for law firms, looking at validation and approval, or sorry, let me rephrase that, looking at ensuring that that asset, the data asset on a blockchain is recognized as property or as an asset by the local law becomes very important for next steps. And this could be a financial asset or any other asset that we're looking at. The third thing just to talk about is a technology versus application. A lot of times when you think about blockchain, people think about Bitcoin, right? But what is the key to look at it is like the internet. When you think of the internet, you don't only think about all the illegal activities or not safe for work activities that take place. The internet is the technology layer. Everything using the internet on top is an application. Blockchain is the technology. Cryptocurrencies are an application on the blockchain, right? So that's a key difference to notice, and hence blockchain as a technology has wide applications and does not have anything necessarily to do with cryptocurrencies when you're deploying it for legal purposes or otherwise, right? Just an example of how smart contracts can be used for transparency in legal documentation. They can be used for reducing document security, patent approval times, because all the sourcing can be done very quickly. Chain of custody can be transferred very quickly if all the processes are automated. Now, it's very important, as with artificial intelligence, for blockchain that all of this data and processes need to be online, right? They need to be digital first, so you'll have to digitalize everything before you start using blockchain. So some more examples of looking at blockchain and different use cases, from enforceability issues to privacy issues. As a blockchain, if a blockchain is fully transparent and showcases all information, there could be privacy issues that come up with a blockchain. So protection of data becomes an issue, and we are seeing that come in the EU, where we are talking about you have under GDPR the right to forget, but in a blockchain, it is not possible for a right to forget because it is meant to be immutable and non-erasable. So you will see some challenges that kick in compliance with certain data laws as well. The last, just a brief overview on that, is we are seeing quite a bit of progress when it comes to virtual assets, crypto as it were, where jurisdictions across the Belt and Road are looking at a variety way of dealing with it. I would say 3 categories. One is looking at cryptocurrency trading, so which is on a wide scale, from being fully banned in many countries to being fully allowed in a licensed manner. Second is the use of blockchain for what is known as real-world asset tokenization, which is basically fractionalizing a real-world asset like a property or a bond and putting it on a blockchain, which is largely approved in most places and falls under security laws. And it's more of a case of use of blockchain for financial services versus use of cryptocurrencies, because all the elements or majority of the elements there would be digital securities, and we're using traditional financial instruments. And lastly, you're talking about things such as non-fungible tokens, NFTs, which are more for marketing, and the use of blockchain broadly, which is not regulated globally. However, most jurisdictions now have a blockchain policy, including in mainland China when it comes to the use of blockchain. And many of the large giants of technology in the region, including Alibaba and Tencent, have been using blockchain extensively over the last 5 to 10 years. One last thing that I want to touch upon is the concept of DAOs, which is decentralized autonomous organizations. These organizations are essentially organizations where there is shared ownership of that asset, and decisions are made collectively, and each person is supposed to be a part of the community. A bit similar like when you have societies where there's a vote that each person has, and then there's a distributed governance structure that takes place. Now, in this case, figuring out liabilities for any wrong action or whenever there's a dispute that arises becomes very challenging. Very few legal jurisdictions have any laws and frameworks for DAOs currently, but this is starting to become a major hurdle and challenge when it comes to legal profession dealing with virtual assets. And we are seeing some regulatory actions in the US that have taken place on DAOs where everybody involved, and that can go into hundreds of thousands of people, right? So enforceability becomes challenging, but there are some cases that are going that could be on your watch list. So with that, I end, and thank you very much again for the opportunity and for listening into this conversation. Thank you.
Thank you, Musheer. Again, wonderful presentation. Again, I'd like to reiterate that Mr. Yang focused on data as gold, Professor Chao focused on rule of law as gold, and now Musheer has focused on processing of technology being the ring gold in itself, but how each one of them presented the advantages and also the disadvantages that we have to look at. The DAOs is, if you look at this book called Spiral Dynamics, it is at level 7, right? Because that kind of thinking cannot even be achieved unless human beings achieve that type of thinking, which is unified, a common element, a common asset, and to this extent, it's excellent. Musheer has also had, you've spoken about blockchain on halal blockchain for us in the Islamic Finance Committee of the Law Society. But for smart contracts and blockchain, I think what it shows in the change of role is that we need to make sure, Professor Zhao just explained to you as well, and remind you that our young students need to study technology, although some of them may not like it because they don't deal with the quantitative aspects. They think law is simply qualitative, but I think that's an important part. As far as the prompt engineers are concerned, they're a different breed of people, and I know some of them, or most of them, whilst we describe AI as something fascinating, can be changed, these prompt engineers, and I've heard this repeatedly, they call the machine a dumb machine. Because they say it's dumb because I can make it do anything I want. And that's why they're so paid highly, because they understand how this thing that we say is so fantastic, they understand just by analyzing it, basically it's black box, right? They don't know how the coder has coded it. So it's a black box to them. But based on the output and the inputs they put in, they've become engineers. From noise. So they are, I would call them black box engineers, all right? So that's a wonderful presentation. I think you will all agree. I'd like to ask Mr. Yang a question, if I may, right? In your opinion, when lawyers provide legal services in the field of data for enterprises, you spoke about enterprises, what aspects should they focus on to improve their service capabilities so as to fully respond to the needs of the enterprise? Would you be able to?
刚才这个分享发言中啊，讲了这个数据产业既对这个经济社会发展带来的机遇，同时啊，给我们律师行业也带来了很大的机遇。数据产业的发展，使我们律师行业啊有机会深入到这个数据产业链的各个的环节。 有机会全面了解数据产业发展中的难点与痛点问题，这就为我们 解决好数据产业中的合规问题，数据产业中特别是竞争的问题，我们就有机会啊，利用我们的专业的优势啊、实践的优势啊，提供更加精准、更加全面的法律的解决的方案。同时，随着这个数据的这个资产资源的促进的频繁，那么律师行业要服务企业的数据的促进，那不仅仅是要对我们国内的相关的这个规定规制的要求、监管的模式要有深入的了解，要帮助企业在这一部分啊，这个做好符合这个合规要求的各项的法律服务工作。我们也要注意啊，境外的不同的对数据出境的合规的要求，以防范相关的法律风险。那么最后一点呢，对于这个数据的产业，它对于我们律师的法律服务而言啊，它就是一个专业。但是因为数据产业它在发展中啊，它涉及到数据的企业的确权啊，前面我说的这个要这个入表，这个在财务报表要体现出来，涉及到数据的安全与合规，涉及到数据的交易与流通，还涉及到数据的知识产权的保护，以及在数据的运营中所遇到的、所产生的争议、纠纷、诉讼。实际上啊，我们从事这个数据这方面法律服务的律师啊，还要进一步的做好专业的分工，为企业啊多层次、多方面的法律服务来展现我们的能力和智慧谢谢。
Thank you, Ms. Yang. Professor Chao, I got a question that I just thought of just now, since we were discussing before. You've made excellent use of the World Justice Project report and the what you call the World Governance indicators. If I were to ask you to create an index for BRI countries, what elements from your experience now would you incorporate into an index that would be required, which would look at BRI countries specifically, and then a comparative? What would you do so that if we, as those that go out into the world, know which questions we should ask? Because we've got for instance, we have Law Society has many MOUs, more than 46, I think now. We can ask those questionnaires and then share it with them as well. So I'd like to just hear your views. I know it's hypothetical, but it'd be interesting.
Well, thank you so much, Amir. That's a brilliant question. I guess for indexing exercise, the quantitative components of the indexing exercise are relatively data-driven. So they will hinge very much on the availability of data, reliable data. Now that is becoming more accessible with the use of technology. I think my learned panelist has emphasized that is becoming more available.
Yes.
I guess the more challenging components here are the so-called qualitative components.
Yes.
In particular legal cultures, norms, social norms, and the practices which in pretty much an invisible way have shaped the way in which legal services have been provided, legal transactions have been structured, and the legal disputes have been solved. So these are the components, these are the aspects that are making indexing exercise, especially reliable indexing exercises, become increasingly challenging. But with advancement of technology, I do have faith that even those more qualitative, traditionally difficult aspects of the indexing are becoming more possible.
Yeah. I've got a follow-up question on that.
Sure.
This is again, it occurred to me just now. When they were analyzing immigration officers, how they perform in relation to clients that go through, they had great difficulty looking at it quantitatively, you know. So some company, I think if you remember, in Norway, designed, and I remember seeing this, they designed the smiley faces, happy, sad, or thing. Keep it really simple. And that was I suppose, a quantitative way of analyzing something which is qualitative. And Professor, you talked about one of the indexes is, I think the World Justice Report looks at the experience based on those factors, right? So if it's experiential, that's one way. I don't know if you can answer that. And also, Musheer, you can understand how it's a brilliant way to consider what Professor Chao has just said. Professor Chao, have you got any? Sorry to put you on the spot. It's not pre-designed, but
these are brilliant questions. Let me try to answer these two questions in a reverse order. Sentiments are important, feelings are important. We're human beings, but the downside of measuring the feelings and the sentiments is that they can be shifting sometimes in a rather fundamental way, in a rather short spell of time. So that's the challenge. I think that's pretty much the nature of human beings. Yeah. I guess that probably boils down to the question of how much real-time data a smart system can gather on people's feelings. But just use American presidential elections as example. Yeah. I think that we can clearly appreciate the turn of the sentiments, the turn of people's attitudes and feelings in that kind of context. So I'm not really answering your question, the second question. But the first question, I think I have been newly appointed as a dean. So my experience as a dean is limited. But if I were to put a system in the corridor, in the classroom, to measure the facial expression, the facial recognition of my colleagues, whether they're happy, the students are happy, my suspicion is that I might well face a revolt somewhere. But I do recognize the importance of the use of technology. I think these are very controversial issues, i.e. the use of more advanced facial recognition techniques for example, in enforcement of law, not to mention the HIO processes. But I think there has been a rather rich discourse globally on how those technologies can be used in a legal and ethically sound manner. Now, so obviously, the more recent European legislation on the use of AI can probably be used as a reference point.
Yes. We actually, I've looked at Principle 1.07, as said in Guide to Professional Conduct. I found that I compared the EU Act with our Principle 1.07. I found that we based it on principle-based, as you were looking at, Professor, and I found that I didn't have to change Principle 1.07, but drafted commentaries, and I didn't compare that with the EU Act. And I put in things like manipulative, etc. But, Musheer, you know that those people who are, where they have been doing it, we use more facial recognition on our phone. It won't take long before the facial recognition can read your emotions, as it does. And people have used emotions and questionnaires in order to be predictive about how an election would turn up. So all these are already possible at a lower level. Can you suggest an answer as Professor Chao as to how, from your experience, if you have experience of this or ideas, as to how you can create parameters in order to assess how people experience the rule of law? I mean, World Justice Report has, to a certain extent, got few parameters, but how would you introduce factors which allow Professor to judge the experience of the rule of law?
It's a challenging one, right? I think when we are talking about...
Possible,
not
because
impossible,
people are doing it
not
already.
Impossible. I sometimes feel that we overrate how there will be pushback for use of artificial intelligence, right? At the end of it, it is about utility, right? There were these conversations a few years ago where it was, people were asked how much do you value your personal data, right? So what dollar value would you put, right? Quite
Yang has-
evidently,
Mr.
this is
Yang
like
has spoken about that.
$70, $80 or something like that was in parts of Europe
Yes.
and parts of US. But in large parts of Asia and say Africa, people were not really putting a high value to their personal data,
yeah.
right? Because there's a very different perception on the utility of that. So if you're able to qualify the utility, and of course with the right safeguards that Mr. Chao and
Mr. Yang
Mr. Yang
about,
spoke
yes.
about, I think the key element is the trust element, right?
Yes.
So all of us have like our the social security data, Aadhaar data, or like here the HKID data. It's all there, and we believe that this has been stored securely, right? And those information. So if you're able to say the same way, you could use artificial intelligence, which can forget. It can be anonymized, right? It checks, forgets, right? So the auto deletion of data can take place. Because one key thing that when we look with deal with artificial intelligence is quite often overlooked is data bias.
Yeah.
Right? Because the quality of the data is very recent. Probably the amount of data generated in the last 2 decades is more than all the data that was generated globally much before, right?
Yeah.
Just for the fact that you have so many devices, you have so many electronic elements to record that data and have that data in place, right? And we are generating these billions of videos on YouTube and TikTok, etc., which never existed before. So just as a scale. So, that example of an immigration officer, I would say that irrespective, if once it's there, I would say 99% of the results will be positive, because when you're going crossing and as an Indian national who has to go through a lot of immigration checks,
Yes.
because we don't get visa everywhere, but you do have to go through that. I'm just going to be smiling and I'm going to finish, and I'm not going to say red if I didn't like the process. I'm just going to say green because I don't want a hassle, right?
Yeah.
I've gone into a place once and I was smiling, and the immigration officer was like, "Why are you smiling?" So I was like, "I'm happy to be, here," but that kind of element. So you have that bias where you don't want to upset somebody.
Yeah.
So facial recognition actually is a better way to recognize whether, I know in the university may be a challenge, but broadly people may be happy with being judged on the performance if you have a mechanism that's trustworthy. So trust for me is the biggest element when it comes to use of artificial intelligence in terms of how the data is used. And probably the best idea in my view is a bit like CCTV cameras, right? Every hour or something, they just get refreshed or cleaned out if there's no use of it. In a similar way, it can be just take the point, erase. Take the point, erase. So then you can't accurately, or the AI can be designed to just see the expression and nothing else of the person. But because AI, as you said, they're already using AI for determining depression in people as well. So that in itself tells you where you're like voice plus video and people's emotions, etc. They're able to fairly accurately determine that as well. So yeah.
I think we've come to the end of our session. I'm 1 minute over, but I'd like you to join me in thanking the speakers.
Thank you very much for the insightful sharing, and we now certainly have a better understanding of the topic. We now invite Mr. NASIR to present souvenirs to the speakers as a token of appreciation. Now, let's invite President Tong for a group photo with the speakers and Mr. NASIR. Thank you, President Tong, and our distinguished speakers.
Over the past few years, Our Belt and Road conferences has been immensely successful in fostering collaboration and synergy among lawyers associations and legal organizations globally. During our inaugural conference in 2017, we have introduced the Hong Kong Manifesto. We pledged to promote synergy, strategic partnership, and collaboration amongst the signing organizations and their members. At the second conference in 2018, we initiated the Law Tech Alliance to celebrate the common goals to ensure that the industry use the legal technologies ethically, professionally, and responsibly.
The application of AI tools to automate repetitive tasks and to analyze huge amounts of data has no doubt helped increase productivity and efficiency of legal services. Yet from different real-life cases, we are aware of legal AI's limitation and ethical concerns of the misuse. Today, we are much honored to have the unwavering support from various organizations from across the globe to physically and electronically sign another manifesto, the Legal Ethical Code of Conduct regarding the deployment of AI. May we now invite Ms. Careen Wong, Vice President and the Vice-Chairlady of 7th Belt and Road Conference Organizing Committee, the Law Society of Hong Kong, to introduce this year's manifesto. Ms. Wong, please.
Good afternoon, ladies and gentlemen. On behalf of the 7th Belt and Road Conference Organizing Committee of the Law Society of Hong Kong, I would like to thank all the lawyers' associations and legal organizations who have joined us today to solidify our manifesto, the Legal Ethical Code of Conduct regarding the deployment of AI. In January this year, the Law Society of Hong Kong released the position paper, The Impact of Artificial Intelligence on the Legal Profession, which attempts to contribute to a comprehensive understanding of the impact of AI for lawyers and legal service users. Today, the signing of this manifesto will bring us to the next level of AI deployment in terms of shared vision and joint efforts. As the regulator for solicitors in Hong Kong, the Law Society of Hong Kong acknowledges that artificial intelligence represents breakthrough opportunities for the legal profession. In essence, our manifesto today is about the ethical deployment of legal AI. In particular, may I quote from the manifesto a line that well represents the signatories' commitment. We should together facilitate the use of AI in a way that aids, not hindering, fair administration of justice, while serving the legal profession and the society at large to advance world peace and prosperity. The idea of AI itself is purely robotic and mechanical. Ultimately, it is the lawyer who should retain the human-centric ethos within the digital solutions. Before we enter the manifesto signing, I would like to express our heartfelt thanks to EBRAM International Online Dispute Resolution Center for their secure and private web-based e-signing service that allows our vision to be transcended beyond geographical barriers with our international connections. Thank you.
Thank you, Ms. Wong. Today, we're very delighted to have 16 legal organizations joining us today for this shared vision. May we now invite these organizations to come to the stage for the manifesto signing ceremony. The signing will be conducted on eBram's e-signing platform. The signatories to the manifesto are, in alphabetical order, AALCO Hong Kong Regional Arbitration Center, Darlene's Lawyers Association, who is joining us online today, Long Guan Lawyer Association, Yi-Bram International Online Dispute Resolution Center, Ganski's Bar Association of Attorneys at Law, who is joining us online today as well, Highland Lawyers Association, Kazakhstan Bar Association, who is with us online, Macau Lawyers Association, Malaysian Bar, who has signed the electronically signatory separately.
And we also have Myanmar Bar Association, who join us online, Sabah Law Society, Seoul Bar Association, who will e-sign separately, Shenzhen Lawyers Association, the Bar Association of the Kingdom of Cambodia, who join us online, Zhejiang Lawyer Association, Zhuhai Lawyer Association, and last but not least, the Law Society of Hong Kong.
May we now invite the representatives to sign the manifesto. Thank you very much. Please remain on stage for a group photo.
Thank you very much, and please be seated. We will now have another group photo. Thank you very much, and please be seated. And to conclude today's conference, we are honored to have Mr. Nick Chan, Chairman of the 7th Belt and Road Conference Organizing Committee, to deliver the closing remarks. Mr. Chan, please.
President Roden, past presidents, council members, fellow friends, thank you again for your trust in the organizing committee. And would like to again thank everyone for coming today. Would like to thank the government for their generous support, Yibram for the technical support, all our sponsors. And I've learned a lot today. I hope you have too, apart from getting our great CPD points. So in all seriousness, the Belt and Road is a wonderful initiative, and it has brought a lot of economic progress to a lot of people around the world. And we hope in the next 10 golden years of the Belt and Road, we could do more together. Apart from infrastructure connectivity, we'll be building more people-to-people ties. You've heard about how to use technology properly, cooperatively, how to use technology, green finance, green tech, and how we could build ties in educational institutions as well. So these are super important. So together we will prosper, and we will build a more multipolar world where we will all do well. So lawyers have a lot to do, a lot to gain as well. So thank you once again for coming to today's conference. On behalf of the Law Society, if I may, thank everyone for coming today. Thank you very much.
Thank you very much, Mr. Chan. On behalf of the Law Society of Hong Kong, we would like to express our gratitude to the Professional Services Advancement Support Scheme of the Government of the Hong Kong Special Administrative Region for their funding support. Also, we would like to say a big thank you to all of you joining in person and online today. Thank you.
And for the guests who are invited to join our dinner, our colleagues will show you the direction to the dining venue, Lapton's Restaurant of the Ocean Park, Hong Kong. Please gather at the hotel lobby at 5:45 p.m. Our colleagues will walk you to the restaurant.
We look forward to seeing all of you in the Law Society of Hong Kong's future events.
Goodbye.
Goodbye.